This webinar is to provide information. We can't provide legal advice, but helpfully we will be talking about the way in which people can access legal advice.
Before we begin, we would like to acknowledge that we are hosting this webinar today on the lands of the Kaurna people and acknowledge elders past, present and emerging. We acknowledge the traditional custodians of the various lands on which you all are working from today and joining us from today, and extend our respects to any Aboriginal and Torres Strait Islander people participating in this webinar.
Okay. So we're delivering this webinar as part of Law Week, which I'm sure you've all been very eagerly awaiting, the #1 week in the South Australian calendar. Look, in reality, we accept that it's not the most exciting week. It probably only squeezes into people's top 5. And we recognise that for the most part, people want as little to do with the law as possible. People generally want to avoid legal conflict. But like it or not, the law is everywhere. When we're driving our car, when we want to cut down a tree, and generally when we're interacting with other people, the law tends to pop its head up, and it can have a significant impact on us. And that's one of the purposes of Law Week. It's an opportunity to increase public knowledge of the law and how to access legal help. And that provides a nice segue to talk about what the role of the Legal Services Commission is, who we are. Now, we could answer this question by telling you that we are an independent statutory authority. And I mean, that is important in a legal sense. It means that we have independence in performing our functions. But it's the function that we want to talk about today. And our primary function is that we exist to provide legal help for all South Australians. We believe that everyone has the right to information and advice about the law and what it says. We want to make the law accessible to people so that they can understand their legal rights and responsibilities. We also want to make sure when people's rights are significantly at risk, when their liberty is at stake, or arrangements in relation to the parenting of their children are in dispute, that they have access to legal representation if they are not otherwise in a position to pay for a lawyer themselves. To provide our services, we receive funding from the state and Commonwealth governments. And as identified on this slide, these are the services that we provide to help individuals in South Australia navigate their legal problems. In today's webinar, we will seek to highlight these services, the areas of the law they can assist with, and the particular assistance they can provide. Now, the natural starting point is the first icon on this page. We provide free legal information and advice.
So if somebody in South Australia is experiencing a legal problem and doesn't know where to start, we recommend calling the legal helpline. The helpline is available Monday to Friday, 9 a.m. to 4:30 p.m. By calling 1300 366 424. There are no eligibility criteria that is attached to this service, and anybody can pick up the phone and give us a call. To increase the accessibility of this service, those who require the assistance of an interpreter can contact us by calling the telephone interpreter service on 131 450 and then asking to be put through to us. For those that have a hearing or speech impairment, they can contact us through the National Relay Service. All of our other services can be accessed from the helpline, and in this way, it works like a bit of a triage in a hospital. It's about identifying what the legal issue is, what information you need, and whether we can resolve your concern in the context of a telephone call. In some instances, a phone call will not provide enough time to unpack the legal issue that you might be experiencing, or there may be paperwork involved that you may want to show the lawyer. That being the case, it may be more appropriate to access a face-to-face appointment instead. Like the legal helpline, this service is free. There are no eligibility criteria and is available to everyone. These face-to-face appointments are available at all of our offices, including Port Augusta and Whyalla, and outreach services in Mount Barker and Murray Bridge. Again, if anyone requires an interpreter, we will arrange and cover the costs of that. Appointments are typically booked for half an hour, but if an interpreter is needed, we will set aside an hour. We will also set aside an hour if the legal issue is connected to family and domestic violence, recognising the complexity of legal and social issues that this can give rise to. Our face-to-face appointments are available Monday to Friday during business hours. And whilst we don't generally offer legal advice services outside of these hours, we do have a number of ways in which people can access legal information. So if we start with 24 Legal, accessible through our website at www.lsc.sa.gov.au. And as its name implies, it's available 24 hours a day, every day. So if you click on the link that the arrow on the screen, on the slide is pointing to, from there you are brought through to a screen that looks a little bit like this. And as you can see, you're presented with different topics covering common areas of inquiry, from cats and dogs and the law to consumer rights and elder abuse. You can select the topic most relevant to your inquiry and further narrow down until you get the information that you need. So for example, if you perhaps have lost your job and you felt it was unfair, or you wanted information about what the law says, you could click on the employment and then it lists a number of subtopics, including unfair dismissal. Clicking on that provides a plain English summary of the relevant laws, as well as links to further information and other resources, or where to access further help.
We've also developed a number of publications and resources covering specific legal topics. These resources and publications can be accessed by clicking the tile on the front page of our website, and then you have the option of either utilising a search box or searching or browsing by topic or intended audience. These resources and publications include everything from guides to the family law system, to dealing with noisy neighbours, to a resource that we've developed called Law for You, which is available in 14 languages and is designed to assist new migrants to learn about South Australian law. Electronic copies of all of our publications are available on our website, but if you are seeking a hard copy, you can complete the online order form on our website that is available on the link to our publications and resources, and we can send it out to you. We can also accept requests for bulk copies. The other resource that you can access from our front page is the Law Handbook. It describes itself as a practical guide to the law in South Australia, but that doesn't do it justice. If you wanted to gain a pretty thorough understanding of the law in a particular area, this would be a really good resource to use. This is a resource that lawyers have been known to turn to if they are looking at a new issue. Now, it might be going too far to call it plain English, but it's definitely plainer. It groups together the law in a particular area, so it has the legislation, case law, and it includes links to the definitions of legal terminology that it's using, as well as links to the legislation that it's referring to and other external publications. Again, to use the Law Handbook, you can search or browse by topic, and it is constantly being updated as the law is being updated. It and all the services that we have spoken about so far are available to everybody for free. Before we get into that, I'll just show an example of what it looks like if you are using the Law Handbook. So for example, if you were to look at information in relation to wills, estates and funerals, it brings that up and then it has a list of topics that you can then click through to. So it starts with what a will is. You can then click next and it will cover who can make a will. And then you can go through the related topics: will clauses, changing a will, contesting a will. So again, this service, like all the others that we've mentioned, are free. They are broad services that can provide that initial information or advice in relation to a broad range of legal problems. The services that we will now move on to talk about are the ones that are focused more on particular areas of the law or legal issues. So let's start with our family and domestic violence legal services. As mentioned, we can provide legal advice to anybody in relation to the many legal issues that are either directly or indirectly associated with family and domestic violence. And we will provide those longer appointments, as mentioned, for those where this has been raised as a concern. Our family and domestic violence legal services, however, are specifically funded to provide additional legal assistance for these issues. Our funding allows us to provide these services, generally speaking, free of cost. but the services will vary in relation to the legal issues that they can assist with and the location where these services can be provided. As part of this, all of these services are funded to allow us to provide assistance specifically to women. So if we first look at our domestic violence unit, this service has a very broad remit in relation to the legal issues that it can assist with. For example, for women seeking to protect themselves from future acts of abuse, this service can assist with advice and representation in court in relation to obtaining a protection order, or what the court would refer to as an intervention order. It's important to pause there, as people might be aware of that larger conversation that is occurring in both legal and non-legal spaces about the criminalisation of coercive control, and that increasing recognition that abuse is more than just physical violence. The way in which the law interprets abuse for the purpose of something like an intervention order, or some of the other legal issues that we'll be talking about today, is a much broader definition than perhaps the criminal law may take. There's that recognition of abuse can be subtle, that it can be a pattern of behaviour, and that it can involve a range of tactics. In relation to the other services, though, that the domestic violence unit can provide, they can also assist with tenancy matters. So if somebody is renting a property, but they seek to end that tenancy, and they need to make an application to the South Australian Civil Administrative Tribunal to do that in order to make sure that they don't accrue any further rental costs, or so that they aren't liable for any damages caused at that residence, this team can assist them with that process and representation for that. It can also assist women with the legal aspects of separation, obtaining parenting orders, obtaining property settlements, minor civil claims, a variety of legal issues. They've also had success in having debts either partially or wholly waived. In line with the broad scope of this service, working alongside the lawyers in this team is a dedicated support worker. And that's in recognition of the fact that social and legal issues are often heavily linked together. Now, whilst the scope of the legal issues that they can assist with is broad, the service is funded to assist women in the northern suburbs with outreach to Port Augusta, Whyalla, and Port Pirie. I should mention, though, that the definition itself of what is in the northern suburbs is defined broadly. Also, this service is funded to assist those who are or who have been subjected to domestic violence, as in abuse from a partner or a spouse. They can't necessarily assist in relation to those who have experienced family violence, abuse from a family member. Again, there is no cost for a woman accessing this service, and it's not means tested.
So unlike the DVU, the Women's Domestic Violence Court Assistance Service, or WDVCAS, is a statewide service. It provides legal assistance to women in metropolitan Adelaide, as well as those in regional and rural South Australia. It can assist women experiencing both family and domestic violence. The legal assistance this service provides is focused on helping with obtaining intervention orders, tenancy issues, and liaising with the police. But it can look to provide appropriate referrals where other legal issues arise, and can also provide a referral to one of our mental health support workers. Like DVU, it is a free service that is not subject to a means test, how much you earn or what your assets are. And they can be contacted directly on 1800 246 642. In addition to these two services, we also have a number of health justice partnerships. For today, we will focus on the partnerships that we have with the Women's and Children's Hospital and its associated network, and with the Lyell McEwin Hospital. Our health justice partnerships are not an outward-facing service. Rather, they are a service that staff at these sites, doctors, nurses, social workers, can refer a woman to. A referral would only ever be made with that woman's consent. These health justice partnerships exist in recognition of the fact that healthcare professionals are often a point of contact, and in some instances, the first point of contact for people experiencing family and domestic violence. We have a lawyer based at the Women's and Children's Hospital each morning, Monday to Friday, and a lawyer available to accept referrals and or attend the Lyell McEwin Hospital at request.
So next we'll talk about the services that are offered by our Civil Law Division. At the end of this, I think it will be appropriate to have a bit of a break. We'll check if any questions have come through, but just to rest your ears and eyes from the webinar that we are presenting. So the assistance that our Civil Law Division can provide is in relation to migration and some decisions that are made by SACAT, who we previously mentioned, decisions made in relation to NDIS funding, and decisions made by Centrelink. I will start with migration as it operates slightly different to the other three that I've mentioned. We offer a free legal advisory service to migrants and refugees through our Adelaide office. Now, we can't assist in relation to all visa types. For example, we generally don't assist applicants for student or skilled visas, but there are a range of visa or migration issues that we may be able to assist with. Permanent protection visas, for instance, safe haven enterprise visas, or situations when a visa is cancelled or refused based upon a failure of the character test. The easiest thing to do is, if you are experiencing a migration issue, is to contact the legal helpline or to call the migration section directly on 8111 5539 to request that initial appointment. In that appointment, they will be able to determine if we can assist, and if we're not able to assist, we will attempt to make a referral to another appropriate provider. So then, SACAT, NDIS, and Centrelink matters. Now, as mentioned, our legal advice team can provide that initial legal advice and information in relation to a broad range of legal areas, including these. But in relation to each of these processes, however, people may be eligible for additional assistance and, in some instances, representation once people have reached a particular part of the process with SACAT, NDIS, or Centrelink. So what do I mean by that? Well, in relation to SACAT, one of their responsibilities is to make what are called community treatment orders or inpatient treatment orders. Essentially, these orders are made for people living with a mental illness who are unable to agree to treatment, and this may be a risk to either themselves or to others. In this instance, SACAT can make an order requiring that they receive certain treatment either in the community or in a treatment centre. If such an order is made, SACAT will give people the details of their rights to seek a review or an appeal of this decision, and that's where our lawyers can come in. Similarly, SACAT can make what are called administration or guardianship orders. These are orders that would be made if there is a concern that somebody has begun to lose their capacity to make decisions in certain areas of their life. SACAT can look to appoint somebody who is then given the ability to make decisions on behalf of that person. Again, if an order like that is made, then our lawyers may be able to assist if that person wants to review or appeal that decision. And it's a similar situation with those people who are navigating the National Disability Insurance System and dealing with the National Disability Insurance Agency. So if somebody makes an application for funding and funding is refused, or they disagree with the amount of funding that has been provided, they can seek to review that decision internally and then externally. And it's at this point that we may be able to provide advice and, if appropriate, representation for that review. And then with Centrelink, if a decision is made denying somebody access to a particular benefit, they can seek an internal review. And then if they are still unhappy with the outcome of that, they can seek an external review. And then again, in certain instances, we may be able to provide representation in relation to that external review. For people seeking to review those particular decisions by SACAT or decisions about their NDIS funding, referrals for advice and representation are made then through to us, and we would then follow up with it rather than people applying directly to us. But again, if you are in doubt, the easiest thing to do is to contact the legal helpline, and they can identify where you are on that pathway and what assistance you may be eligible for. So we'll have a break now. We'll check whether or not any questions have come through, but please feel free to stand. So a question has come through. Can you recap the website address and phone numbers? So the website, LSC, as in an abbreviation of Legal Services Commission, lsc.sa.gov.au. The telephone advice line number is 1300 366 424. And the number for Woodvicus is 1800 246 642. All right. Next, we'll move on to talking about the Criminal Law Practice Division and our Family Law Division. The services that these divisions provide are often linked to whether or not somebody has a grant of legal aid. And we'll talk about what the eligibility for a grant of legal aid is, and later we'll talk about the process for applying. So our Criminal Law Practice Division. This is the largest criminal practice in South Australia, and it can provide advice and court representation to persons charged with criminal offences. So if we first look at the starting point of the criminal justice process, let's say you're at home, police attend, and they say that you're under arrest. In that particular situation, it's important, or it may be important, for you to seek legal advice to understand what is going on. And if it's during business hours, people are able to call the Legal Services Commission to access arrest advice and look to protect their legal rights from the outset. But for people who are arrested outside of these hours, it's the weekend, it's late at night or early in the morning, or it's a public holiday, Christmas Day, New Year's. The lawyers in our Criminal Law Practice Division staff an after-hours advice service to assist people arrested on serious charges, what are called major indictable charges. And generally speaking, that means charges where the maximum penalty is greater than 5 years imprisonment. So there's that access to legal advice, protection of your legal rights. The lawyer staffing this advice service may then notify our division's duty solicitors. Now, our duty solicitors are often described as the paramedics of the criminal justice system. They can assist anybody who is in custody and has to appear before the court. So when somebody is arrested, the police need to make a decision, and that decision is whether or not they release that person on a set of conditions with a date to come back to court, and that's called releasing that person on bail. Or they might say, no, we think it's important that the court decides whether or not this person gets bail. And that's where the duty solicitors can come in. They can go and speak to that person, give them advice, get their instructions, and then help that person apply for bail. If the duty solicitors can also provide a degree of limited assistance to people who aren't in custody but are otherwise required to attend court on that day. But their first priority is to assist those who are in custody, and it's advisable to seek legal advice well in advance of attending court where possible. Legal services also fund the provision of duty solicitor services in our regional courts, where somebody has been arrested and is due to appear before the court, but has been unable to obtain legal representation. If an arrested person is granted bail by the court, they may be eligible to apply for legal aid, i.e. that means they'll have a Legal Services Commission will pay for a lawyer to continue to represent them in relation to their matter. And we will talk more about the process of applying for legal aid as mentioned shortly. But generally speaking, a merit and means test determines the eligibility for a grant of legal aid in a criminal matter. Now, for the means test, that essentially means that the person is not otherwise in a position to pay for their own legal representation. The other part of the eligibility criteria is that the charges that the person is facing are such that there is a risk of imprisonment. It's in those instances that a grant of legal aid would be appropriate. Now, if legal aid is granted, that won't necessarily mean that the representation will be free. It will be expected that a contribution will be paid, and the minimum contribution for a criminal matter is $50. If somebody is refused bail by a magistrate and a duty solicitor is acting, then the duty solicitor will typically complete a legal aid application on their behalf. And that application is going to be fast-tracked to ensure that the person in custody has access to a lawyer quickly, and they can provide their instructions to their lawyer, and that they can then get that ongoing representation. Grants of aid for criminal matters can be assigned to private practitioners or to one of the lawyers in our Criminal Law Practice Division. The Criminal Law Practice Division represents eligible persons charged with criminal offences across all jurisdictional levels. So we have lawyers appearing in the Youth Court, Magistrates Court, District and Supreme Court, through to the Court of Criminal Appeal and the High Court of Australia. Now, that's a very brief overview of the Criminal Law Practice Division, but in essence, assistance can be provided from somebody's original arrest through their first court appearance and up and including an appeal against their conviction or the sentence imposed. If we then turn to our Family Law Practice Division.
So we are going to touch on Amica, which is an online tool that was developed by National Legal Aid. Now, it goes without saying that a couple separating can come to an agreement themselves as to how they wish to divide their property or what the parenting arrangements will be moving forward. Amica is an online service available to everyone that can assist in reaching agreement in these areas. The service is free to use. Each party enters their details and then it uses AI to take into account the relevant factors to each to reach a fair agreement. And whilst it's free to use, there will be a cost if you want the service to prepare formal paperwork, a parenting plan, for example, or if you want it to prepare the paperwork that you need to submit to court. The fee involved is significantly lower than having someone else draft the paperwork for you. Now, it's important to note that while the service is available to everyone, it won't always be appropriate for everyone. The more complex the situation, the less amicable the separation, the less likely it will be appropriate, and it won't be suitable where there are family violence or safety concerns.
But then let's say you haven't been able to reach agreement through Amica or otherwise, and you need to start accessing legal processes. So you know how I said at the outset that people generally wish to avoid legal conflict where possible? In many ways, that idea is reflected in the family law. Before a separating couple can make an application to resolve their property or parenting dispute, they're generally required to establish that they've taken genuine steps to resolve the dispute. I say generally, as in some cases where it may be urgent or there are family and domestic violence concerns, some of those requirements may not apply. But part of the process of establishing that you've taken genuine steps, and particularly in relation to disputes in relation to parenting matters, is taking part in what's called dispute resolution. Now, there are a range of dispute resolution options that people can participate in. The dispute resolution service that's offered by the Legal Services Commission is legally assisted family dispute resolution. So, family dispute resolution. This would be a conference hosted by a neutral chairperson trained in family law, and it allows the parties to attempt to reach an agreement with the assistance of their lawyer present. And this means they won't necessarily have to come into contact with the other party. And in this respect, it offers a safe and independent dispute resolution process. And the Family Dispute Resolution Unit at Legal Services has a high success rate in assisting families reach agreement, and that then provides a quicker and less stressful way to resolve issues than going through the court process. To be eligible to access this service, at least one of the parties involved in the dispute must have a grant of legal aid for that family dispute resolution. Now, we talked about what the eligibility for a criminal law matter is, but eligibility for a family law matter, again, has that similar means test, that the person is not otherwise able to afford their own legal representation. In relation to a merits test, or the other aspect of the eligibility criteria, the starting point is that there needs to be that genuine dispute in relation to children, in relation to future parenting arrangements. That said, in instances where the dispute is only in relation to property and the person seeking to gain legal assistance would otherwise meet the means test, they may still be eligible for a grant of aid if special circumstances can be established. This really speaks to whether it can be identified if the applicant would otherwise be at a disadvantage or would otherwise be vulnerable. So that might be English might be their second language. They might have low literacy, a disability, or there might be that presence of family and domestic violence. These are things that might otherwise allow someone to access a grant of aid in those circumstances. And in some instances where court proceedings have already commenced, the court can again refer the parties back to dispute resolution if it considers appropriate. If dispute resolution does not resolve the matter, however, and the matter is now proceeding to court, then subject to a grant of aid, lawyers in our family law practice can provide that ongoing legal representation. Again, our advice section can provide otherwise in relation to the various aspects of the family law process. When a matter is before the court, in some instances, the court will consider it appropriate to appoint what's called an independent children's lawyer, or an ICL. Their role is to represent the best interests of the child. And again, in our family law practice division, we have accredited ICL lawyers who can perform that role. Now, the reality is that the vast majority of family law disputes will resolve prior to proceeding to trial or the trial commencing, but it can still be a long process to get there. But if a matter does reach trial and the parties or one of the parties does not have legal representation, the court can make an order banning the parties from being able to directly cross-examine the other in circumstances where domestic and family violence has been identified. Essentially, in that instance, they will need to have a lawyer to ask the questions on their behalf of the other party. And part of this is to protect against that risk of the court system being used by one party to potentially continue their abuse of the other. And Legal Services Commission is funded to provide discrete funding to cover that cross-examination, that questioning of the other party by a lawyer for eligible persons where such an order is made. As you can see on the slide there, in our family law division, we also have the child support unit who offer advice and limited assistance to payers and payees on a range of child support issues. This service can be accessed by calling 8111 5576. And then, like the criminal law practice division, we also offer a duty lawyer service at the Federal Circuit and Family Court of Australia, including when on circuit it travels down to Mount Gambier. It's otherwise called FAS, the Family Advocacy and Support Service. Unlike the duty lawyers in the criminal law section, the FAS service provides both a duty lawyer and a social support service to assist people with their family law matters. The duty lawyers can provide advice, assistance with adjournments and legal aid applications, and provide referrals to private practitioners and other services. They won't be able to prepare complex court documents or represent parties at interim, contravention, or final hearings. This service is available during office hours, Monday to Friday at the Adelaide Registry, and during the Mount Gambier Family Law Circuit, as mentioned. In relation to the services that can be offered by a support worker, you can see that we have a family social worker, a men's worker, and a mental health worker. And they can help engage that person with the family law processes and help and identify to do with things like safety planning. No appointment is necessarily required to access these services, but priority is going to be given to clients who have a hearing listed in court that day. The service is not means tested, but again, where it's appropriate that the person be legally aided, they can assist with that process. They also offer an outreach service to the Magistrates Court to assist individuals there who are defendants in relation to intervention orders, for example, in the family violence list. But again, there is that preference to organising one's legal representation in advance of a court hearing. It can help to take away some of that stress by being able to get that fuller understanding of what the process will be through the advice of a lawyer. And this brings us through to applying for legal aid. Now, we've mentioned on a number of occasions that grants of legal aid can be provided to people in relation to criminal and family matters. So we can act, the lawyers in our family section, our criminal law section can act on those grants of legal aid. but we're also responsible for determining grants of legal aid. To make an application for legal aid, you can now do it online through our portal that's on our website. The benefit of using the portal is that you have the option of creating an account that will enable you to track your application. You can update your financial details if necessary. You don't have to create an account though, and you can simply use this portal to complete an application as a guest. If you're not able to access the portal, you still have the option of completing and then lodging a physical legal aid application. Our application forms can be accessed and downloaded from our website, but are also available at our offices, and they can often be located at courts, private law firms, and community legal centres. Whereas the portal will prompt you as to the additional paperwork that you need to submit with your application, this information is otherwise included in the front cover of the physical application form. Once you've completed the hard copy of the application, you can then either submit it at one of our offices or you can send it to us electronically via email. And the email address is listed there. When completing the form, you have the option of nominating your preferred solicitor, and that can be one of the lawyers employed in our criminal or family law division, or it can be a lawyer from a private firm. Now, I'll be honest with you, the form really asks for a lot of detail. It's going to ask you about how many cars you have, their make, their model, about boats, about caravans, about shares. It's a lot of information, but that's essentially so that we can get an accurate picture of your financial position and also as much detail as we can about the nature of your legal problem. And that's to determine your eligibility for legal aid. It's not always a perfect science though, and sometimes it can be hard to fully reduce your situation onto the form. But there is that option on the form of including extra detail. You can include other information that you think may be relevant. If you need assistance in completing an application, then you can book a legal advice appointment to assist with this process. If your application for legal aid is refused or granted, either way, you will receive notification in writing. And again, you will receive details about your options to review that decision.
Now, the last service that we want to talk about is what we are doing now. At the moment, we provide free legal education services or sessions across South Australia in schools, in prisons, to local councils and a range of other community groups. We have targeted programs for particular groups. For example, I myself deliver a program recently developed by our team that involves 6 different workshops for young people. The workshops have been developed with consideration to SACE and the Australian curriculum, and topics range from rights and responsibilities online, interactions with the police, and consent and healthy relationships. However, we are also happy to take requests on as well. So you can contact us about a particular topic or legal issue, and we can work together to come up with a solution that best suits your needs. And you can request those sessions through our website. An extension of this is our Law for Community Workers program, recognising that community workers can play a key role in assisting their clients to access legal help. We run a program called Law for Community Workers, which is a free education program targeting workers in all fields of community work. We host free legal webinars just like this one, and the best way to make sure that you are kept aware of any upcoming webinars is by subscribing to our monthly resource called Keeping Connected. Now, I appreciate that many of you tuning in probably have already subscribed, and that's how you found out about this webinar. But for those of you who aren't subscribed, every month we send out an email identifying any relevant legal topics and resources and any events that we've got coming up. So I highly recommend subscribing. April's email, for example, referred to the significant changes in family law that came into effect on the 6th of May. So it's a very valuable resource.
And that brings us to the end and back to where we started. Now, we've talked about a lot of services. We've used strange acronyms like WOODVICUS, or said things like the Family Violence and Cross-Examination at Party schemes, provided a number of emails and telephone numbers. And we accept that it's not realistic to expect people to remember all of these terms, all of these details. Now, I know that we have said this a lot throughout the presentation, But the big one that we hope people remember is our 1300 number, or just that there is a 1300 number, and that people can access that to begin to understand the legal problem they are facing. Thank you so much, everybody who's tuning in.